SJC-13721, Town of Concord versus Neil Rasmussen and others.
Okay, Attorney King, whenever you're ready. All set.
Good morning. May it please the court, Gwen King on behalf of the appellants. Before the court today is a question of both how a way becomes public and also how a public way is discontinued and ceases to be public. During my time, I'd like to address 3 issues for the court. First, the effect of the 1932 discontinuance by the Middlesex County Commissioners under the 1924 Act to discontinue public ways. Second, whether a way can be deemed public by virtue of a lost layout where there is no evidence regarding when it was laid out, who it was laid out by, and most importantly, under what authority it was laid out. And third, whether the court should eliminate the high bar of establishing a public way by prescription where the claim of public prescription is an ancient claim. First, as to the effect of the 1932 discontinuance, a fundamental rule of land law is that a way is public until it is legally discontinued. Well, what is a legal discontinuance? It is a discontinuance according to law. In 1924, the legislature...
Just to be more specific, there's 3 different ways, right? There's 32A, there's 21 and 30, right?
Correct.
Aren't you sort of saying all 3 work exactly the same? I'm a little confused by your argument that they're not doing different things.
Well, they definitely have different procedures and in some instances different outcomes. So Section 21, let's take that first.
Just pin you down and I'll let you talk, but my understanding is that in your view, all 3 of those turn it into a purely private way, right?
Well, with a slight distinction, Your Honor. So under Nylander, this court held a Section 21 discontinuance, which is a discontinuance at town meaning of a townway, and only a townway under Section 21. Doesn't leave any abutter access rights. There's no private way left intact after Section 21 discontinuance per this court in Nylander. However,
I thought the footnote in Nylander is the big is the foundation of their argument for why this remains still public.
so the footnote that's emphasized by the town is referring to a subsequent version of 32A, and in that, this court noted that that leaves intact public access rights. Now, we have contended in our brief that what the court was construing as public access rights is distinct from how the town characterized it. Most notably, as you can see in the underlying appeals court and superior court decision in Nylander, public access private way was referring to a butter's private rights of access. And I emphasize that as an important point because, as we note, the public right to travel is the public easement that is laid out under Chapter 82. The public right of access is not something, and this court in the 2002 case, Chandler, actually noted the distinction and said you can't lay out a way for access. The public right is only that of travel. And that's inconsistent with what is clearly the legislature's intent in the 1924 Act. Because in the 1924 Act, they say it's no longer needed for common convenience and necessity, and it's not needed to be safe and convenient for travel. That's inconsistent with the concept of what a layout for a public way is needed to be for, to be safe and convenient for travel. The inverse decision was adjudicated by the county commissioners here. And the adjudication is a very important point as to the distinct meaning of Section 32A.
Can you, I have, I think, a somewhat related question to Justice Kafker's question. If we look at Section 21 as it was in effect in 1932 and Section 32A as it was in effect at that time, what is the difference in outcome? Are you saying that that action under either section would result in exactly the same outcome?
No, I'm not. And the question actually shows why Section 32A was so important to municipalities and the Commonwealth at the time. So first, as to the jurisdiction of Section 21, that only applies to townways. However, the jurisdiction of 32A applies to public ways, which the county commissioners had jurisdiction over all public ways at the time. And it's important to go back in time to 1924 when thinking about the jurisdiction of the county commissioners. They had authority over public ways being county highways, townways, and any public way of unknown jurisdiction. So that's an important distinction because here, where, as made clear by the case before you, what this way was at minimum uncertain. So the county commissioners would have the authority to discontinue it under 32A, whereas the town would not have authority to discontinue a county way under Section 21.
I didn't see anything to suggest this was a county way.
Well, to the contrary, the town contends that there was a 1763 county layout of the Northern Trail that was effectuated by the county commissioners. We have disputed whether that was effective because the conditions precedents were not fulfilled. The town notes in their brief that, and relies and emphasizes that certain deeds of the Northern Trail referred to the way as a county way.
So are you saying that Section 21 was not available to Concord for this way in 1932?
My suggestion to the court is because it was clearly unclear what the status of this way was, 32A would be the way to resolve it. And if it had been a town way, as the town contends, yes, it could have been discontinued by Section 21 and Section 32A because it applied to all ways. And as to both Justice Kafter and your question about what is left after the discontinuance, so because an adjudicated private way is expressly left intact by the county commissioners, recorded as such, reported as such, that is what is left, a private way with private easement rights over it for the abutters. Practically, the import of that is that abutters would not have to be paid by the municipality landlocked damages. And the emphasis of why that's important and that distinction matters is made clear by this court's analysis in Nylander. Nylander was concerned about what title examiners and subsequent property owners would be on notice if there was just a Section 21 discontinuance with nothing further to illustrate that there was a private easement over a private way left intact.
Isn't the same thing true for the abutters?
No, Your Honor, because here we have an adjudicated private way left intact. And noted by REBA and noted by the Massachusetts Association of Land Surveyors and Civil Engineers, that's what was left on the record. Here, if you look at...
No, but why would that give record notice to anyone of what easements it precisely existed over it?
To the extent that the private way was recorded, the private easements would then be left with the private abutters, and they could extinguish it as they pleased. The burden here, as noted by the REBA amicus brief, I think is really important to note because a public way, you cannot adversely possess a public way. A private party cannot adversely possess a public way. But in situations where a private way is left intact and there's no longer a public right to travel over it, as expressly adjudicated here under the 1924 Act, the private way can be agreed to among the various abutters, or often the case, as we see throughout the examples, there was only one private abutter, and they can do with what they want. But the question of what is on the record to put people on notice as to what rights, the question here is what told anybody that after this discontinuance, which has a legal...
I mean, it seems like all the law is going against you. That's every case the land court case, we've got the case by Chief Justice Piper again. We've got this Spicer's decision here. We've got a lot of appeals court authority drawing this distinction that 32A really just deals with maintenance. What's your best case that comes out your way? And it just seems like everything is flowing the opposite way, and I'm having trouble. I see you trying to distinguish, making these fine distinctions, but it just doesn't seem like you've got support for a lot of this.
I appreciate the question, and I think it actually calls out why the question before the court is a narrow one. We're talking about the 1924 Act. The majority of cases that the town relies on refer to the 1983 Act and analyze that.
Whether the 1983 Act is really just reformulating the 1924 Act in many ways, and it's just expanding it to cities or whatever it does. I mean, there's a big issue that it's the same. And Nylander relies on an earlier appeals court case. Is that also a 1983 Act? I can't remember the name.
Yeah,
of the
so
case.
that's Coombs, and that's a 2008 appeals court case.
Okay.
And Coombs was dealing with whether or not,
Coombs
and
is a 1988 case, isn't it?
what did I say?
You said 2008, but
I'm
it's
sorry, 1988. I got the last number correct. A 1988 case dealing with the 1983 Act. And Coombs actually does illustrate that there were substantive differences of the 1983 Act. Most notably, the question in Coombs was whether a municipal board could eliminate its responsibilities over a county way. And the Coombs court said, no, it was substantively changed. The municipal board doesn't have authority over county highways. Again, illustrating the difference with the prior version, not only the superior quasi-judicial authority of the county commissioners.
But what you're saying, what Coombs actually says about the prior statute is completely the contrary to your argument here. Coombs talks about how the prior statute worked, and it is consistent with earlier cases that describes the operation of the statute. And you made an argument that they had no notice of, with what the import of the 32A discontinuance was, but they have the benefit of the law itself, of 32A itself, do they not?
When you say the benefit of the law, do you mean the benefit of the 1983 law?
Benefit of the notice of the 1924 version of 32A. Even if they say, for example, they all were operating under a collective misunderstanding, right? So they should have filed under Section 21. They should have followed the process in 21. They misunderstood what they were doing, and they did a 32A discontinuance only. And under 32A, it just means that, the town doesn't have to pay for the maintenance of the road anymore. Just because they were under a collective misunderstanding of what they had done, that doesn't change the nature legally of what they did, does it?
Well, to the extent that there are legal terms utilized under the 1924 Act, those are the words that we need to be considering and when we construe the effect of the discontinuances. And I understand from the town's argument, they say, look, the statute's ambiguous, we should look to subsequent case law as to what it meant. Respectfully, Coombs didn't exist in 1924.
They're not saying look to subsequent case law. They're saying the cases at the time, the closest thing we've got, opinion of the justices, which is 43 or something like that, they're explaining that there's sort of an historical interpretation of, don't just say private means private. It's much more complicated in dirt law, there's a history of doing this, and I understand that some of the amicus think this is more unsettling, but this seems to be more novel. Again, but and isn't there some logic to having the town, if you're going to eliminate all public use of a property, having a town doing it through 21, which is a town meeting, as opposed to the road commissioners who deal with road maintenance? Is there some underlying logic to that?
Well, again, I don't want to confuse the 1983 version, which has to do with the road commissioner's authority at a municipal level with the county commissioner's authority.
1983 is basically modernizing the terminology and not really changing the substance, right?
And I really do want to make 2 points about that I think are important, because appellants at no point have conceded that 1983 is not necessarily a full abandonment. The question has never been squarely decided by this court, and with respect to the footnote in Nylander, which was clearly dicta, 2 years prior to Coombs, Justice Cass in the Mass Appeals Court case, Carmel, cited the 1983 32A discontinuance as being a method for full legal discontinuance. And he instructed that should a public body want a discontinuance, they can so act, and then cited to the 32A.
What's the site to Carmel? That's in your brief? 'Cause
It is, and the site is, excuse me 1 second, 21 Mass App 426.
And just because, again, Judge Cass, this is his expertise, he says what?
He says if a public body wants to discontinue a way, it may so act. And then it cites to, among other things, noting the concept that you can't, from lack of use, a municipal way cannot be abandoned, right? And that's been a concern of this court.
Doesn't seem to suggest anything helpful here.
Well, the fact that
he's not saying that 32A allow, he doesn't say 32A constitutes elimination of public rights, does it? Does he say that in Carmel?
He most certainly does not fully expand upon the meaning of 32A, but I think it is significant when he's emphasizing that there needs to be public body action to discontinue a way. He cites the 1983 version of 32A. And again, I stress that the 1983...
Can you just finish that thought? Because I heard the words that you said, but I don't come to the conclusion that you draw.
So
Cass cites to the 1983 version of 32A for what?
as a proposition that it's a method of legal discontinuance. Now, the import of legal discontinuance was stressed in this court in Preston v. Newton in 1917. And the idea is that we don't want public ways to become deemed unpublic by lack of use. There has to be formal process for discontinuing ways. Here we have an act, a 1924 act, that was entitled an act for discontinuance.
But what do we make of the fact that it didn't actually say that in the statute? You know, the other statutes, I think it's 21 and 30, both use the word discontinue in a legal sense, and this one doesn't.
You're correct, Your Honor. It only says it in the title.
Right, and so do we take anything from that?
Well, to the extent that the land court deemed that the act was ambiguous in its usage of private way, which it did here, yes, you would look to the title of the act as showing what the intent was. And I think as stressed by the North Andover amicus brief.
But how do we know which kind of private way was intended?
Well, I think that's the question, right? So by 1917...
Yes, it is. Thank you. That is my question.
Yeah. So by 1917, we understand, if we look at the municipal treaties that was cited in our reply brief, that this is the difficulty of Commonwealth law relating to public ways. Private way historically had been used to mean both purely private ways and in some instances open to the public.
Right.
That is a complicated fact that this court has dealt with on multiple occasions. But we know that by 1917, as reflected by that municipal corporations, that ambiguity was well recognized.
But isn't that ambiguity way less ambiguous when the entire point of the provision is to decide who has to pay for the upkeep? Doesn't that strongly suggest that at least, even though this is a deeply ambiguous term in general, when you have a statute, Section 32A, that's literally about who has to pay, the public-private distinction there is a little clearer, that we're talking about whether it has to be privately maintained or publicly maintained?
I'm not sure that you could read Section 32A to say it only has to do with maintenance, because it says it's no longer needed for common convenience and necessity, and the inverse of that was a requirement of laying out a public way. So in a judgment by the county commissioners...
The fact stated in the statute is that the town's no longer on the hook for maintenance.
Unquestionably, the town is no longer responsible.
And so I think, you know, to Justice Stewart's point, the kind of public way that is adjudicated under 32A might be the kind of public way that is still private way, the type of private way that is still available for public use.
But then we must look to the rules of statutory construction, and it was an abuse of discretion here for the land court to exclude other evidence of how Concord, public bodies charged with administering the statute, utilized it. And as we see just from the discontinuance documents in this case, it was clearly understood at the time to be a full discontinuance of the trail. The private abutters in 1932 said, the way is almost impassable, it's a fire hazard, can you close it? The road commissioners granted that petition and then in turn petitioned the county commissioners to discontinue the way.
But it clearly wasn't fully discontinued because people are continuing to walk on it all over the place, right? And it's part of a trail system there, right? I understand they're not driving their pickup trucks through there, but aren't they, it's being used, right? And that's why we're here, because there's a big fight over whether to shut down this kind of walkabouts.
I think that brings me to a very important point of this case. The town in this case initially actually brought a public prescription claim for both post-1932. They dismissed it because they were going to be unable to prove it, presumably. So really, when we say there were people walking on the trail, that goes to a point that this court has often emphasized, is we defer to private parties allowing people to open the trail. Here, the private owners did subsequent to their acquiring the process and the properties in the 90s, open the gate, maintain the trail, and welcome the public onto it. The adage "no good deed" is apt here.
Is this the same gate that Emerson's daughter drove through, or is this a different gate? There's a gate that supposedly existed in the 18s.
Correct. There was a gate.
Is this the same gate you're talking about that they want shut, or is this a different gate?
Well, I hate to characterize it as they want shut. The question here is who has control over this way. As you can see from not only the underlying case, but the amicus briefs in here, the facts on the ground here is that there is a wide range of trail systems over private land. This court has never held that the fact that a private trail exists on the ground and is used by recreational walkers is alone enough to establish a public way. And indeed, in dismissing their claim.
But if it was a public way and it continues to be used as a public way by anyone, and again, we've got findings by the judge. I mean, they're incredibly detailed findings that, this was a popular walk or drive for a very long time, and it sounds like that's continuing.
Well, respectfully, there's no evidence of that because the town dismissed the claim that it was continuing post-1932. So to the extent the town now tries to throw that in as a characterization, I argue that's really not before the court, and some of it is quite inaccurate. But the question that the Lane Court did opine on really bears to a significant legal issue before the court on the public prescription claim, and that is one of direct proof. That has been emphasized by this court for claims of public prescription in going all the way back to Durgan, Balukian, and Boxborough, and most significantly Sproul. The importance of the direct proof criteria for a claim of public adversity is that you presume that use is permissive over private ways already existing unless there is direct proof. If you study the land court's decision, yes, he did write an 87-page opinion and it's full of findings, but they are full of inferential findings based on speculative opinion testimony. This trail would have been used by public walkers. It would have been used. It would have been used. There is sparse evidence to find the direct proof that it was used in any specific way.
You've got a travel book from the 1880s that says this is basically the photos of 1880s telling you to go travel on this route. Isn't that an example that it was a route?
Well, I think no. And the reason is we don't want private property owners to gate their ways for fear of having public prescription claims put over them. The court has recognized that time and time again. That's why the presumption is that it's permissive use. It was an error of law. The land court ignored that presumption and actually clearly misstated it in several pages of his decision. Here, what we can surmise from Thoreau, who notably speculated that the trail had never been accepted and that the only trespasser was the proprietor itself, and Emily Emerson, who said that the gates, she had to go through gates, which would break any public prescription claim. And yes, you referenced the travel thing, but does this court want to set the standard that the new bar for public prescription is if a blog posts that this is a good place to go for dog walkers? That's what that would be. And the reason that you see the amicus briefs come in, I contend, is because if the court does adopt the lower court's rationale, you are drastically reducing the high bar for public prescription if it's an ancient claim. And when you consider what the court did here, or what the town did here, is they said, we can't meet the high bar of establishing a public prescription claim over the last 90 years. We're going to reach back in time 200 years to establish it. I know I am well over my time. If there are any further questions.
Thank you.
Thank you.
Okay, Attorney Anderson.
Good morning, Your Honors. Austin Anderson for the Town of Concord. I think Your Honors correctly identified that the key issue here in interpreting the statute is the meaning of the phrase private way. The meaning that the land court adopted and that we advance here is consistent with how that phrase is used throughout Chapter 82. And we understand that it has had different meanings in different contexts over time. As Justice Kafker pointed out, the cases on that are legion, and I don't think there's any dispute about it. But in Chapter 82, it is consistently used to mean a way that has public access rights. In Section 21, it talks about towns laying out and discontinuing private ways. In Section 24, it talks about using eminent domain to create a private way. And this use of private way stretches back to the very earliest laws about ways in the Commonwealth, back when you used to have highways that ran between towns and private ways that were within towns. And private ways were what is now, what we later called a townway, were open to public travel. So read in context, Section 32A's description of adjudicating that a way shall thereafter be a private way is properly understood to mean a way that has public access. The distinction between public ways and
What do
private
we make
ways.
of the fact that the 24 Act was called an act to discontinue?
So the title of the act is an act respecting the discontinuance of certain ways as public ways. There's no dispute here that after 32A, it is no longer a public way in the sense that it is not maintained by the town. And that's the distinction, the relevant distinction in Chapter 82 between a public way and a private way is who has to pay for the maintenance. I think it's clear from the language of the statute that that's the focus here. They give authority to the officials having charge of the way, which is the road commissioners. And importantly, it's not just the 1983 version of the statute does that. The 1924 version also says the petition has to come from who in Concord would have been the road commissioners, the officials having charge of the way. Those are the people responsible for ordinary maintenance. So you have the people responsible for maintenance submitting a petition asking that it be adjudicated a private way. The point of the statute is to discontinue maintenance obligations. It doesn't say anything about public access rights. Another important way we know that is that it doesn't.
What do we make of, the one thing that gives me some pause on that is the sentence about notice, that sufficient notice to warn the public against entering thereon is posted. So that's sort of, that's troubling, right? It's inconsistent with having people walk on there and go through there, right?
So critically, that same exact language appears in the 1983 version of the statute, which this court in Nylander recognized preserves public access rights. And read in context, which again is all about maintenance, that warning is understood as a proceed at your own risk sign. You post it where the newly adjudicated private way enters upon a public way so that people traveling know that they can no longer rely on the way being maintained in a condition safe and convenient for travel. The other way we know the focus is
To cover your rear by the municipality provision, that's what it is?
exactly because the municipality is no longer maintaining the way, it needs to warn people in order to avoid liability for injuries caused by
Can I
defects
ask
in the
you
way.
to address opposing counsel's argument that this was a county way, and so that it wasn't a town way that could have been discontinued under the other sections?
Yes, so we have the layout document, or at least the northern portion of this, which refers to this as a town way and a private way. A private way, an open way, so it's clearly subject to public access, but it uses the terminology private way, town way.
So your position is that based on those documents, that it's actually a town way, not a county way?
Yes, exactly. It's clear that this was a town way.
Does a townway need to be confined to the limits of the town?
It does, and in 1763, this was confined to the limits of the town. Before,
What about the portion in Carlisle? No?
Carlisle was not its own town until 1780, so in 1763, this was entirely within Concord's limits. We also know that the layout refers to connecting to an existing town way, referring to the southern portion. So there's evidence in the town's records that both of these are town ways. The land court also goes through the statutory provision under which the 1763 layout was accomplished, and although it was the county who approved the petition, it was a similar process to 32A, where they first went, or sorry, not 32A, but Section 30. They first went to the town to try to get the way laid out. The town wouldn't do it, and so they appealed to the county. So although it was the county that made the decision, they were laying it out as a town way because it was all within Concord.
Wait, so which section was that you're just referring to?
This is the Sessions laws from 1713.
Section of the way, so I'll just refer to them as the appeals court does. There's the northern section, the southern section, and then the undisputed section. Which section was there an appeal process to the county commissioners?
That was the 1763 layout for the northern disputed
For the
section.
northern, okay.
And the undisputed section is also a town way, or is that, or what's its characterization?
That is, so, yes, it's also a town way. It wasn't disputed, there's no finding of facts on this. But importantly, that section that is not disputed has exactly the same provenance and origin as the southern disputed section that we're talking about. There wasn't any distinction between them until 1932. So, this is the way by Benjamin Clark's we talk about in the surveyor's records. That included the currently paved, undisputedly public section and also the southern disputed section. So there's no basis for distinguishing between them.
Is the word adjudicate used? I saw reference to the many places where discontinuance or discontinue is used throughout the chapter. What about adjudicate? Is this the only section where something can be adjudicated?
I believe so, Your Honor, yes. And so that's an important point about the text and why the title of the statute about discontinuance as a public way doesn't trump the text of the statute itself, which is, as the land court recognizes, clearly trying to do something different from what Section 21 and Section 30 were doing. And actually, the parties agree on this, that 32A is not simply duplicative of those other sections. There must be some different legal effect. Their position is that it leaves intact private abutters' rights. Ours is that it leaves intact the public's right of access. If you look at the statute, the text of the statute, there is no mention of private abutters' rights. Its focus is on maintenance. Its focus is on the officials having charge of the way. It doesn't make sense to read that, given the difference between the procedures under 32A and the procedures under 21, it doesn't make sense to conclude that the difference in effect is that one preserves private access for abutters and the other does not. The focus is on the public's rights, whether the public requires maintenance, whether the public is required to expend funds to maintain the way. Of course, the other critical difference is the role of town meeting. And I think it is clear, I mean, the Mahan v. Rockport case as a town way may be discontinued by a vote of the town and not otherwise. When Nylander is talking about the...
But then 30 allows you to go back for a second bite. I find that sort of odd,
Yeah, so 30 does give a limited, basically an appeal right. If the town doesn't agree, you can go to the county. I think...
Is that an appeal or
Well,
are they a higher body? I'm just confused by that.
Well, if you look at Chapter 82, there's a clear distinction. It's got the chapter, the statute as it was existed in 1932 and in 1924 had different subsections. The first several sections were about county commissioners' authority over county ways. The next section was about town authority over town ways. This was added to the section about town ways. This was a procedure by which the county could get involved in a town way. And so 30 gives a limited exception where if the county is on notice that the town has already considered this issue and has decided not to discontinue it, and they give extra protections in the form of notice and payment of damages, then in that limited circumstance, they can act to discontinue the way. Reading Section 32A to allow the county commissioners to do exactly the same thing without having to go to the town first, and without those protections of notice and damages, first of all, would render Section 30 completely superfluous, but also would be an expansion of the counties.
Because to a couple of other issues, so again, I know you don't want us to consider the REBA brief or the conveyancer's brief because they come in late, but tell us why the sky isn't going to fall if we affirm this, because It is a bit troubling that we've got these two expert groups very concerned about unsettling the waters here. So tell me why they're overreacting or why they're not accurate.
Absolutely. So I have three answers, Your Honor. The first, as an initial matter, it's important to recognize that neither side is offering you an interpretation of this statute that avoids the problem. The other side is saying it preserves an unrecorded, unwritten private easement for abutters that would cause exactly the same problems that Reba and the other amici briefs are worried about. In fact, we know as a practical matter, when you have a property dispute, it's most likely your neighbor that it's going to arise with. That was the Nylander case. That's common sense. The second answer is that this, as you recognize, Justice Kafka, this is the only interpretation of this statute that is out there. In the case law and other authorities, nobody has ever said that a 32A discontinuance extinguishes the public access right.
The case law is interpreting the 1983 statute, not this one.
So I think Coombs is our best case on this, and I understand it's an appeals court case, it's not binding here, but Coombs was explicitly talking about the pre-1983 version. And of course, the land court goes into all the legislative history and explains why the amendment in 1983 made procedural but not substantive changes, which I think is compelling. But for practical purposes, Coombs put people on notice in 1988 that it was at least possible that a discontinuance under 32A preserved public access rights, and we haven't seen the sky fall since then. That was 37 years ago. There's been no flood of litigation. This issue hasn't come up. And frankly, it makes sense because the only time you're going to have a dispute is when you have a road like this one that was discontinued and then continued to be used for recreational purposes afterwards, continues to exist on the ground. If you have a rewilded way or something that's been built over, it's obvious that nobody was using it. And so as a practical matter, you're not going to have these claims arise. The final answer is that there's an easy fix in Section 21. If the town, to the extent any town was mistaken about...
Can I ask another sort of open-ended question? Do we need to deal with this footnote in Fenn? And because the appellants say, again, they're saying, well, we're opening up stuff with this footnote in Fenn, and the prescription analysis by the judge may be more aggressive than has been in the past. Is this a case where we really don't have to decide either of those two issues because the combination of its prior use and the fact that it had to be discontinued establishes that this is that kind of limited private way or, quasi-public private way? I'm just trying to figure out how much we need to decide here.
So I think you do need to decide that there were public access rights in 1932 at the time of the discontinuance.
Right, but I get that, but can the fact that they had a I understand it's not dispositive that they had to discontinue, but the fact that they did discontinue and they did maintain the highway, the roadway, and we've got lots of evidence that it was a road, and do we have to get into these more esoteric issues, like whether a birder's 1880 book is enough for prescription or whether we need to establish that missing book? I'm just trying to understand how much we need to decide for you to win.
So you do need to decide. I think you do need to decide the question under Fenn, but it's not, first of all, it's not a footnote. Fenn is talking about how it's drawing on and synthesizing earlier case law and says it's been recognized throughout the ages that it's possible to prove a public way even if you can't locate the specific document. So that's what we're talking about. It's just whether or not the way was laid out is a factual question. Do you need direct evidence or can you make the inference based on circumstantial evidence? Fenn recognizes that the inference is perfectly permissible, explains why that's been the case throughout history. It's been relied on since. And as a practical matter, that makes sense because public authorities have been laying out ways in this part of the world for 400 years, and their legal status should not turn on whether we can today locate the document. The municipal record keeping from that time just isn't perfect. So when we have a way like this one, where all of the evidence, and the evidence in this case is overwhelming as the land court went through. All of the evidence says this must have been a public way. We have the 1763 layout that is completely meaningless unless it connects to another public way that lets you get to Concord Center. We have the surveyor's records, showing town maintenance from the 1760s up through the 1930s. We have all of the accounts of people using the road, and we have the discontinuance where everybody agreed this is a public way, we have to take this step because this is public. Everything is pointing in the same direction. This must have been a public way. So under Fenn, I think this is an easy decision, given the volume of evidence here, that this had to be public.
Sorry, can I ask a technical question? With respect to your argument that the 1763 layout doesn't make sense unless there was a public way there, when you say public way there, do you mean a publicly maintained public way, or just either a publicly maintained public way or what we now call a statutory private way, which is to say a publicly maintained private way?
So in order to accomplish its purpose, the way that the 1763 layout joined to just had to be open to the public. So we don't need to know exactly which category it fell into. We do know, the evidence says that it was a town way. The town meeting document says it was laid out as a town way. We know that the public was maintaining it through the surveyors. We have, Benjamin Clark's.
But there is evidence that the initial roads in this area were privately laid out.
Some of them, yes. So this is a point of confusion, I think, in the briefs. The land court did not actually find that the southern portion of Estabrook Road was laid out as a proprietor's way. It rejected that conclusion based on the one probate record they cite to. Of course, even if it had been initially created as a proprietor's way, there's nothing to stop it from then being laid out as public. We know the 1763 layout follows the path of an existing way. But in order for the 1763 layout to accomplish its purpose, it had to have met with a way that allowed the public to continue to access, otherwise you're just getting stranded in the middle of the woods. And we know that the public was maintaining it. So I see that I'm over my time. Unless there are further questions, I'm happy to.
Okay, thank you.